amongst us, Miss Abhilasha Nautiyal. She's done her graduation from in her BLLB from Army Institute of Law 2010 batch, where she was a bronze medalist for her batch and also a recipient for Chief of Army Staff Trophy and Certificate of Merit for the class of 2010. She later went on and did her LLM from Harvard Law School 2014 batch. Ms. Nautiyal has worked with Anand and Anand from 2010 to 2018, and some of her representative experience include advising and representing SCP holders in dispute resolution and negotiation. Part of her team also represented a multinational renewable energy player in its dispute with its Indian joint venture partner. She has also worked and protected the largest selling whiskey in the world. The part of her team has also handled India's first compulsory copyright license, amongst other experiences. Ms. Nautiyal's practice of areas include commercial dispute resolution, intellectual property, competition law, standard essential patents, that is STP dispute resolution, insolvency resolution, armed forces services dispute resolution, and others. So today's topic for webinar is IP dispute resolution, where she will be guiding us on how to raise and defend a claim. So we welcome you, ma'am, and over to you.
Right. Thank you, Siddhi. So I'll just start with my presentation and I'll take you through it. So I'll try and make it as interactive as possible, but I understand that it'll be difficult for everyone to participate as we go along. Should you wish to have a comment or a question, you could either write to Nitesh and he could unmute you for that duration and we can see if we can make it interactive. So I'll just begin. Give me a moment. Can you see my screen? If one of you could just confirm that you can see my
Yes,
screen.
Abhilasha, we all can see you.
Great, perfect. So the general idea of today's discussion is to take you through the various mechanisms we have for dispute resolution in IP. And as a primer, before we get into the topic really, I'll take you through the various IP protection and the statutes that exist in our country and how one needs to assess which right that you're looking to resolve a dispute for before you actually get into the realm of dispute resolution. So as a starting point, this is a very common image that you would see in today's day and age, where each one of us is booking a taxi using our phones or using some other app. During this single transaction, you would be exposed to multiple intellectual property. So for example, here on the screen, you can see there is a phone. A phone would have uh, possibly patents that protect its components, and each component of the phone could possibly be subject matter of a different patent. In addition to that, you could also have standard essential patents, which is again a specific category of patents, which could be at play here. You could also, the shape of the phone could also be protected. It's possible that certain aspects of this phone could also be protected as a design. In addition to that, there must be a lot of trade secret at play here. The way a company runs its business, what algorithms are being used. So it's possible that certain IP at play in this photograph is also protected as trade secret. Copyright, yes, there is a lot of copyrightable subject matter here. There is a lot of code that is part of the app that is on display. In addition to that, you also have a lot of logos, a lot of brands here. And what about trade dress? There is a concept of trade dress, the way all of this looks together. So a simple transaction in life when you interact multiple kinds of IP every day. And what about the photograph itself? So this is a photograph and that is also subject matter of copyright protection. So the general idea that I'm trying to hash out here is that in a daily interaction, you will witness different kinds of IP. So a single product or a single service could have many facets of IP attached to it. And when you're looking to advise someone, a client on dispute resolution, step one usually is you identify what IP is it, what asset are you looking at, what laws apply to that specific asset. So a single asset could be covered by multiple IP statutes. So usually step one is to understand what the asset is and understand what law will be applicable to that specific asset. Now, what are the laws that we generally need to look at when we're looking at IP protection, IP enforcement? So you would have heard the terms copyright, designs, patents, trademarks, geographical indications. So these are primarily and generally speaking the categories in which law protects intellectual property. Now, how does one understand the compartments of this? How do you understand what will be covered by copyright versus what is a geographical indication? So it's important and interesting and also helpful to look at what is the policy of the law behind protecting different kinds of IP. Now, when we say IP, it's intellectual property. It's something which is the product of one's intellect. But how do we then further compartmentalize it? And let's examine the policy of the law to get a better understanding of this. So if you see the screen right now, you see three columns. The first column is rewarding creativity. Now, here I have bracketed copyright and designs for the reason that the policy of the law behind protecting copyright and designs is somewhat similar, which is to protect and reward creativity in people and entities. So, for example, if we look at literary works, books, and if you look at essays and you look at artistic works and sculptures, things like that, they all get protected as copyright. Design, on the other hand, are aesthetic elements of articles, of objects. So, a shape of a bottle or an aesthetic embellishment on any other article will come in the realm of design. So if you see, copyright usually is in the most non-functional, non-technical aspect of an object, and then you come to designs, which again it goes to an industrial process, but you're protecting only the aesthetic element. You're not protecting anything functional in a design. Once you look at functionality and you come to technology, then you move from this column to the next one, which is patents. So here the policy of the law is to protect technical innovation. Now let's pause here for a minute. Software. Right? Today's day and age, software is hardcore tech, but where does software fall? Of course, there is a provision in the Patents Act for software protection, but it's also an exclusion from the Patents Act, which says a software per se is not protectable. So where does software per se go? It actually jumps back into copyright. So software per se could be protected as copyright and not as a patent. So you'll see how the same IP asset could be protected in multiple ways. A third way of protecting a software could also be trade secret. For example, the Google algorithm is a common example of how an algorithm is protected as a trade secret. But why would one protect software uh, as a trade secret? Why not as a patent? Or how do you choose between these three? So there are different considerations that are required to be weighed in when you're thinking of what is the right kind of protection for an asset. Just to give you an example, if I think a certain technology may not qualify for patent protection, then I might as well keep it as a trade secret, because if you file a patent application, then there is a public disclosure. And if you don't get a patent over that technology, then it's disclosed to the public and everyone can use it. It's in public domain. So you may want to consider a trade secret option. Uh, or for example, the trade-off with patent filing is public disclosure. And if you don't want public disclosure, then you look for other means of protecting that tech. Now we come to the last column, which is consumer association. And here there are two kinds of IP protection, which I've put in, which is trademark and geographical indications. So trademark, I'm sure everyone is familiar with brands that we see all around, and it could be a logo, it could be a sound, it could even be a shape. So there's a whole range of trademarks that are protectable. And there's geographical indication. Geographical indication is a specific trade or a specific skill, product based out of skill that is directly or uh, uh, commonly associated with a certain geographical location. So with these two categories of IP, the policy of the law is to ensure that consumers are able to distinguish and can associate and maintain that association with purity with a certain manufacturer or a supplier of a product. That is the original policy of the law behind why trademarks and geographical indications ought to be protected. Of course, the law has evolved over the years, and the policy has now come to include even the interest of the right holder, which is the brand owner. So, generally speaking, these are the categories in which IP protection may fall. Uh, the reason why it is important for us to know this, even as dispute resolution lawyers, is like I mentioned, step one is always to understand what is the IP involved, what statutes will govern it, so that you can make a conscious decision on which right in which asset is the one that you want to enforce and how should you enforce it. Now, each of these statutes have their own procedures and own uh, rights that are granted. So, it is important to understand the difference in scope of protection and mechanism of protection and enforcement before we actually reach the stage of enforcement or even defending against a claim based on any of the IP rights. So step one is for dispute resolution, like I said, is of course there is a problem. It could be a market source that identifies a problem. It could be consumers that identify a problem. And sometimes even public disclosures could identify a problem. For example, an application or a publication of a journal of an IP office may also disclose a problem. Now, what could be a problem? Someone is copying, someone is not copying exactly, but there is some similarity. So these are different layers or different degrees of actionable claims that can be identified. Market sources are usually one of the most common areas where problems are identified because, of course, if a company is suffering in the market because of an infringer, that is most likely a case where they would want to take action. What kind of action, we'll just come to that. But yes, if it's really impacting the bottom line of a firm or a company, they will identify that problem and they would like to remedy it. Sometimes even consumers can raise concerns, and this is also a situation where a company is likely to uh, want to resolve it because again this impacts the bottom line. If a consumer is getting affected and a consumer is getting confused, then it is something that a company would like to remedy. Applications and journals of IP offices, these can work in more than one way. Sometimes there is actual infringement that can be detected through applications that are filed by an entity or a person and their publication in a journal. Or it could also mean that, clubbed with certain other factors, it could mean there's infringement that is imminent or there is a real threat of infringement. So again, these are areas where companies would keep a watch, right holders would like to watch to ensure that nobody else is eating a part of their pie. So you have identified a problem, and then what do you do? How do you decide, okay, now this is the way to resolve this dispute? We need to collect facts, and to collect facts you need to investigate. Now, what are you looking for? Why do you need to collect facts? You need to collect facts to firstly understand what is a plausible claim that should be made, uh, who are the entities or parties involved, and what is the end game, what is the relief that is being sought. So once you look at these broad questions, you start collecting facts to understand which are the parties involved, what is the act, and what is the end game. You're looking for details of the counterparties, you're looking for details of the cause of action, you're looking for details such as when and where what has happened. um, so usually the client or the right holder could collect these facts on their own and present them to a lawyer. The client could hire an investigator, and there are investigators who are very skilled at this task. the investigator could assist a client in doing it. As far as the role of the advocate is concerned, the advocate does not normally investigate. We cannot testify on behalf of a client, so we don't investigate really. The investigation part is executed by the client or by an investigator on behalf of a client. Another interesting approach on collating facts could also mean exploring the RTI route. Sometimes there are public disclosures to public authorities made by entities where you are suspecting some plausible infringement. So even filing RTIs could yield results where you can understand if a party is interested or is already infringing or is working towards infringing a certain IP assets. To use an investigation in court, you need an affidavit of a person who has investigated. So this could be the client or the right holder or a delegatee of the right holder, which could also be an investigator. So a sworn affidavit by the person who conducted the investigation is one mechanism of using the investigation in court. Now that we have the facts, we have studied what is the IP that we want to enforce, what are the laws applicable to it, we have collected all the facts uh, for the relevant cause of action and the parties involved. Now comes the assessment on how do we resolve this specific dispute. And as you can see on the screen, there's a whole range of options available. And the emphasis that I would like to place on these options is what you need to really understand. There is no one size fits all. This is a range of options. These are tools that you have, and you need to assess the facts in each case to decide which will be the most effective and efficient way of resolving a dispute. So the first one is a lawsuit. If there is a plausible cause of action and there is injury, you may choose to file a lawsuit against a client. But at the same time, you have to consider it should not be that you're using a sledgehammer to kill a fly. If the facts reveal themselves to be such that another approach would be more efficient yet effective for a right holder, it's important to assess and analyze which other option could work equally well. The second option is a cease and desist letter, which is a legal notice. Legal notice can be addressed by a lawyer to a counterparty where you identify what the wrongs are and you give an ask. You put an ask down on paper and uh, make the other party comply with it. Now, there are benefits to a cease and desist letter, and there could also be certain consequences of sending a cease and desist letter, which you must consider before you go down this approach and you advise or go ahead with a cease and desist letter. Now, the benefits of a cease and desist letter, of course, are if you send it, it's cost effective. It doesn't cost as much as a lawsuit. For the reason that it's not a full proceeding, it's a simple letter, it's a one transaction or maybe a few transactions of correspondence, so it's cost effective. There is no court involved, so there is no fee involved to that extent, so it's a shorter transaction. And if someone complies based on a cease and desist letter, it's effective. So why not use a cease and desist letter always to go ahead. Now, in certain situations, a cease and desist letter may be counterproductive. So when you're sending a cease and desist letter to an entity or an individual who you consider or your facts reveal to be a rank infringer, a copycat, a serial infringer, in that sort of a situation, because the entire business model of the counterparty is based on the activity of direct infringement and of counterfeiting, it is unlikely that they will actually agree to a demand based in a cease and desist letter. But a cease and desist letter may, on the other hand, prompt them or give them a warning to go underground or to suspend activity or to disguise the activity even further. So in certain facts, you may not want to start with a cease and desist letter where it could be counterproductive to what you're looking at. A cease and desist letter, again, if not properly drafted, if your claim is not set out, if your rights are not explained properly, could also yield a counter action somewhere in a jurisdiction which may not be more suitable to you or your client. So you have to be very careful in the way you draft a cease and desist letter and against whom you're sending a cease and desist letter. Now, what should be the tenor of a cease and desist letter? That's also an important consideration when you're sending a cease and desist letter. Like, there is no one size fits all in general for the approach that you use for dispute resolution. There is really no one size fits all template of a cease and desist letter either. So you have to see what are the facts, what should be the tenor, should it be a soft ask, should it be a tough ask, should it have a warning, should it have a threat of litigation. So these are all factors that you must consider. Just to give you an example, and this is an example which is often quoted on being a test case, or being an example really in what should be the tenor of a cease and desist letter and in what cases should you send it. So this is a pamphlet or a flyer that was made by the Penn International Penn Intellectual Property Group, which is a part of UPenn Law School, Penn Law. And so this was a symposium organized by students and by faculty of Penn Law in the US. And if you can see at the top of the screen, there was this motif that was used, and I'm sure some of you will be able to identify it. That this is a variation of the famous LV motif. So instead of LV, it says TM, like trademark. So Louis Vuitton is the right holder, is the owner of the LV motif, and they saw this. And of course, if you're a right holder and you want to stop anyone else from using your right, one option to enforce your right or to resolve a dispute is to send a legal notice, and that is what happened here. And that is plausible, to send a legal notice. Most lawyers would advise to send a legal notice. But what this example, I'll take you through what happened after the legal notice was sent, will demonstrate a learning on what could be a tenor, what could be an ask, or what should be a situation where you could even avoid a legal notice. So this is the cause of action. It was this pamphlet based on which a legal notice was sent, and this is an extract of the legal notice, which was sent to the University of Pennsylvania Law School by Louis Vuitton. And it said this egregious action is not only a serious willful infringement and knowingly dilutes the LV trademarks, but also may mislead others into thinking that this type of unlawful activity is somehow legal or constitutes fair use. So you can say it was fairly an aggressive tone that was attached to this letter. Now, as a consequence of this letter, a response was sent back by the University of Pennsylvania Law School, and the response gained a lot of traction in the media. It was put up on the internet, and it drew a lot of comment really on the entire episode. And the response simply was, we think this is parody, we're not using the brand in the course of trade, and there is no likelihood of consumer confusion. So on merits, the law school said we are not infringing, but it went a step further, and that I think is very interesting, is when in the conclusion of the letter they said, if there is any need to discuss this further, please contact me directly. I encourage you to attend the symposium. Educating our students about both the rights and defenses against IP owners is a key goal of the symposium. So the tact right at the end is to encourage a dialogue, is to not precipitate the dispute any further. So this is an interesting way in which you can consider sending a letter, but again, it's really an example, or a lesson in first assessing what situations a letter should be sent in, and then what should be the tenor, what should be the ask in sending a letter. At the same time, it's also a lesson in how to respond to a legal notice that you receive. Uh, the conclusion of the response from the law school, again, the tenor and the way they have kept the dialogue open, again, is a great lesson. Now, another way to resolve a dispute, and sometimes effectively, is a business to business contact. So for dispute resolution, it needn't always be executed through a lawyer's office. It is possible to go back and advise a client or the right holder, or a counterparty, that a best approach in this sort of a situation would be to get the heads of two entities talking, or the responsible people in entities talking. So business to business contact can also yield great dispute resolution outcomes. Another option for dispute resolution is licensing. And again, licensing may not apply, say, against a counterfeiter, for example, but in certain situations, for example, if you're talking about standard essential patents, or you're talking about some technology which the client owns but does not practice itself, in that sort of a situation, a license can also be explored for a win-win. Another example, and this is rarely used, I would say, but can be used effectively, is a PR war. And I'll give you an example, and this happened a few years ago between Stagezilla and Oyo, where Stagezilla put out a tweet and said, Oyo, I think you're using our trademark, you're violating a trademark. So what happened was, Oyo, if you search for Stagezilla on Google, an Oyo ad popped up in which Stagezilla was used. So it says save extra money, book Oyo, why to pay extra in Stagezilla. So the brand was used by Oyo. Now, Stagezilla, of course, had the same options. It could file a lawsuit, it could send a cease and desist letter, business to business contact. License was obviously not an option in that case, but it chose a PR war instead. So what they did was they went out on Twitter and said this. In response to this, what so Stazilla went on and said, "We're sending you a bunch of "Oh Yo Mama" jokes today until you stop infringing our trademark." So they added humor to it as well. Oyo in return said, "Thank you for telling us, and we will fix it." So they were able to resolve this dispute without resorting to any other mechanism, and efficiently and quickly. And then Stacey said, "Great, thanks for letting us know you've complied, but well, we will punish you still." And they went on and they published these Oh Yo Mama jokes for a part of that day. So this is also another option. But again, this is a very tricky option and it doesn't always work. Just in some situations, it may work. Uh, Another option, and especially in today's e-commerce centric situation commercial transactions, could also be a takedown request against infringement. That's also something that can work effectively. This has its own nuances on what IP asset you identified of infringement of, which entity are you addressing it, and what are the requirements in law that you need to do before you send a takedown request. So does it have to be a specific URL? What are the obligations? What can you ask be in a takedown request? So again, you need to consider these aspects carefully before you send a takedown request. There's the assets that we talk about, all IP assets, are governed by the respective statutes, and each statute has its own nuance or own mechanism on cancellation and other proceedings that can also be undertaken against a specific IP asset. So, for example, if the counterparty also has a trademark application, trademark registration, what should you do about it? What should your pleading in a suit do to take care of the registration? Is there something that you must launch for cancellation of the registration? At what stage should that be done? So even these are factors that must be considered. For example, another example is in a patent infringement suit. uh, should you file for cancellation of a patent for revocation? When do you do it? Where do you do it? The timing is critical. You have multiple options. Do you take it just as a defense to infringement? Do you file a counterclaim, or do you file a revocation, or are you still within the window to file a post-grant opposition? So there are many factors that can be considered as a part of your strategy of dispute resolution, is to also look at cancellations and oppositions for the IP asset. Another mechanism of dispute resolution, which is becoming very popular even in IP, is mediation. Mediation could be pre-litigation or it could be during litigation. And we see this in the Delhi High Court and the Delhi District Courts very often, where you can file a pre-litigation mediation. And with the expertise and guidance of mediators, complex IP disputes can also be solved with mediation. Arbitration, of course, is an obligation contract based dispute resolution option. So if you have an arbitration clause, certain aspects of IP can also be arbitrated. All your commercial terms of IP can be arbitrated. However, validity of IP, this is a tricky field. validity of IP cannot directly be arbitrated, and the other commercial terms, of course, can be arbitrated. So these are a series of options that one can consider when you're looking at dispute resolution of an IP dispute. Now, what are the factors when you should bear in mind when you're choosing which option of dispute resolution one must go for? First, of course, is what is the claim? What is the value of the claim? Again, like I said before, it should not be that it's a sledgehammer to kill a fly, or it should not be something which is going to lead to, a whack-a-mole problem where you get rid of one and then another pops up and another pops up. So the subject matter is very important. Who is the opposite party? Is it a rank infringer? Is it an ex-licensee? Is it an ex-employee? That really helps to understand, is it a competitor, to decide which of the options you must pick for dispute resolution. Is there a dispute resolution clause? Is there a prior engagement between the parties? Very important factor, because sometimes this may guide the direction in which you can actually go for resolving a dispute. What is the likely outcome? This is a very important consideration. This will determine your approach and strategy and advice on how to resolve a dispute. Sometimes, in fairness, you have to advise where there is where a case is not made out on merits, whether it's even a path that one should go down or not, is something that you may want to advise. Budget, what is the likely budget of an action, is very important, because you would like the action to be seen through. So sometimes even budget considerations can alter the various options that you have. So normally you would see multiple options will be at play, but even budget can sometimes dictate which of the options is most feasible in a certain situation. What is the duration? How quickly is it likely to yield to relief? What is the expectation of the client? What is the relief? So those factors also play. And jurisdiction, of course. Will it be a jurisdiction of which is distant to the client or the right holder or the party that you're representing? And what will the complications attached to the jurisdiction be? Again, these are factors that you need to consider when you're deciding what options you to go ahead with. Now, a lot of IP disputes fit into the definition of a commercial lawsuit, and also the pecuniary jurisdiction for a commercial lawsuit. So I'm just sharing the general timeline of a commercial lawsuit, and here there are mandatory timelines, at least in Delhi, which are prescribed by the Commercial Courts Act and the Delhi High Court original side rules, which apply to the High Court original side. So I've put those timelines down here. So the way it works is akin to a regular lawsuit. The key differences are, after the admission of the lawsuit, the written statement has to be filed along with an affidavit of admission denial within 120 days from some receipt of summons. And this 120 days now by the Supreme Court has been held to be a strict timeline. It cannot be extended beyond this. So 120 limit, 20 days is the outer limit. It cannot be extended beyond that in a commercial dispute. Now, the original side rules of the Delhi High Court also mandate that affidavits of admission denial have to be filed along with the written statement. Now, after the written statement comes the replication. There is a timeline of 45 days now that is prescribed by the Delhi High Court original side rules, and the Delhi High Court has held these 45 days now by a decision of a single judge of the Delhi High Court to be mandatory. And if you're not filing your replication in the 45-day period, you must at least file your affidavit of admission denial. The same timeline will apply for the affidavit of admission denial. Then there's marking of exhibits, and there's case management hearing and framing of issues. Now, case management hearing is a hearing which is also a sort of a housekeeping kind of hearing that the court holds, where a timeline or a time frame is fixed for the rest of the procedure, the trial, and final arguments by the court. So this is an introduction of the Commercial Courts Act. So after the case management hearing, of course, the matter goes to trial and then final arguments. There are timelines prescribed in the Commercial Courts Act for case management hearings and also for final arguments. and these timelines I've mentioned on the screen. For case management, hearing and framing of issues, it should happen in 4 weeks from admission denial of affidavits. And for conclusion of final arguments, it's 6 months from the first case management hearing. These are timelines that will evolve and will gradually be complied with in commercial litigation. At this point, there is a lot of backlog. There has been a lot of backlog. So these timelines are, there is an intention to comply with them, and hopefully in the near future, uh, the lifeline of a commercial lawsuit will really shrink based on these timelines. The underlying message really is that commercial litigation must be fast. It should not be dragged on for years and years. And that is, I think, the message that courts are now trying to reinforce. Another tool for dispute resolution that has been introduced by the Commercial Courts Act is that of a summary judgment, which is a judgment pre-trial. And that can be filed, an application seeking summary judgment in a commercial dispute can be filed anytime before framing of issues. So if this is a tool that must be used, you have to be wary of the timeline and the exact requirements of in what cases can a summary judgment be granted is provided under the amended Rule 13A, the new introduced 13A by the Commercial Courts Act. One of, if you decide to go ahead with a lawsuit in an IP matter, one of the uh, most complex and ever evolving area is where to sue. What is the territorial or appropriate territorial jurisdiction to file a lawsuit? And this has undergone a lot of shift over the years. And there's a lot of judgment law in this field in addition to the statute. So it's important to know, both as a plaintiff and as a defendant, whether the territorial jurisdiction of a court needs to be tested, or is it already established and is something that can be sustained in court. So this is a very important consideration if for dispute resolution you're looking at litigation. The first question is, when is this challenge to territorial jurisdiction decided? Now, at the time of filing of the lawsuit and pre-trial, the question of territorial jurisdiction is decided only as a demurrer, which means the pleading has to be considered, what is said in the plaint and what is made out as a case for jurisdiction. As long as the pleading is there, a suit will not be returned on the basis of lack of territorial jurisdiction. However, if the written statement and all other documents do make out a case to raise doubt about the facts in the plaint, in that sort of a situation, an injunction may be denied. And this is what the division bench of the Delhi High Court has held. The questions of fact really are then deferred to trial, and only after a trial can the facts be ascertained by a court. Now, why is this question of jurisdiction often litigated and debated in IP disputes? Like any other lawsuit, Section 20 of the Code of Civil Procedure governs filing of the lawsuit as well. However, in trademark and copyright cases, not patents or designs, there is an additional forum that is envisaged and granted by the IP statute for trademark and for copyright. So when you're looking at a copyright or trademark dispute, there's an additional forum, which is where the plaintiff resides, carries on business, or voluntary or actually works for gain. So there is this additional forum, and which is why there's a lot of litigation in trademark and copyright cases on the question of jurisdiction itself. So the cause of action is one way to launch an action in a jurisdiction. In addition to that, you have your defendant's residence or place of working or carrying on business. And a third is based on the plaintiff in trademark and copyright cases. Another aspect of facts now, which impacts the jurisdiction of courts, is the internet and how cause of action arises on the internet. At what places can cause of action arise based on the internet? And secondly, at what places is a plaintiff or a defendant carrying on business based on the internet? So this is another development which needs to be considered when you're deciding or when you're assessing which court will have jurisdiction. So where can a suit be filed? Section 20 of the CPC says where the defendant actually and voluntarily resides, carries on business, or personally works for gain. So it's based on the defendant. Or where a cause of action arises whole or in part. There's an explanation to section 20 of the CPC, which has been interpreted by the Supreme Court in Patel Roadways, which says if cause of act, so if defendant is a corporation and you're going for carrying on business via corporation, in that situation, if there is an overlap between the cause of action and the defendant corporation subordinate office, then court will always have jurisdiction at that place of overlap, and the sole or principal office of the corporation will be ousted for the purpose of jurisdiction. So this is the interpretation that Patel Roadways has made of the explanation to section 20 of the CPC. So just to come back to the slide on section 20 of the CPC, where the defendant is based or carries on business, or where a cause of action arises. But when you're looking at where the defendant where defendant is based, then if it's a corporation, you must consider the explanation and the interpretation given to the explanation by the Supreme Court. So these are the tests that you must run through before you assess and decide which is the court of appropriate jurisdiction under section 20 of the Code of Civil Procedure. Now we bring the two provisions of the Trademarks Act and the Copyright Act in the mix. Here is the additional forum that is granted under both the statutes, and it's very similar in language, which is why I've placed it together. The additional forum is this: plaintiff actually and voluntarily resides, carries on business, personally works for gain. So here, instead of the defendant, it's based on the plaintiff. So it's an additional forum. If Now, what is the meaning of plaintiff carries on business or personally works for gain? This is a question that the Supreme Court has decided, and I'll take you through those decisions on what is the meaning that the Supreme Court has given this phrase. In a decision called Doda House in 2005, and this was a case actually involving the Doda Mithai. The Supreme Court said for personally works for gain, the actual presence of a plaintiff is necessary. So the plaintiff must be physically in that location for claiming that the plaintiff personally works for gain. However, if you're looking for carrying on business, there's a distinction that the Supreme Court has drawn, which is this: carrying on business does not require the presence of plaintiff. It's not a mandatory requirement. Exclusive, special agent, a manager or a servant, where you have control or you have a share in profit loss of the operations, could also lead to carrying on business in a certain jurisdiction. Just because you're selling a product in a certain jurisdiction is not enough, or you're providing your services, that by itself is not enough. You need to show that it's exclusive or through a special agent, or where you have control in the profit and loss of the operations in that jurisdiction. This is what the Supreme Court explained carrying on business or personally works for gain to mean. Now, in addition to this, there is the Supreme Court judgment of IPRS versus Sanjay Dalia, which then tried to further define the jurisdictions which can be availed under Section 62 and Section 134. Now, in this case, what the Supreme Court has held is if there is an overlap. Now, this is another new facet in the mix that you need to consider when you are deciding the court of appropriate jurisdiction. If there is an overlap, like in section 20 explanation we saw, there is an overlap of cause of action and defendant subordinate office, right? So that's what Patel Roadways said for defendant. Now we come to plaintiff. The Supreme Court in IPRS versus Sanjay Dalia said, if there is an overlap of the cause of action and where the plaintiff actually voluntarily resides, carries on business, or personally works for gain, if there is an overlap of these two activities in a certain place, then that is where the jurisdiction of the court under section 62 and 134 will be exercised. So if there is an overlap, that is the court of appropriate jurisdiction. Now, this decision has been interpreted by the Delhi High Court, a division bench of the Delhi High Court, to actually, if there is an overlap, then like Patel Roadways for a defendant corporation, the division bench of the Delhi High Court has said that In case of an overlap of this nature, the jurisdiction with respect to the principal or sole office of the plaintiff is ousted. And this is a decision of Ultra Homes versus Purushottam Kumar of the Delhi High Court. So other high courts have taken different views on this issue, but as far as the Delhi High Court is concerned, this is the view that once there is an overlap of cause of action or part of cause of action, and the plaintiffs carrying on business or where plaintiff resides or voluntarily or actually works for gain, then the jurisdiction of the sole or principal office of the plaintiff then is ousted. So you cannot go under 134 and 62 for based on just the principal or sole office. And these are the examples here that are quoted in the judgment itself. And example number 3, which I've highlighted, is this. A is where the plaintiff has its principal office. Sole office. So we are saying this is a principal office where there could be multiple offices. B is where plaintiff has a subordinate office, and where the cause of action has arisen is also B. So here you notice an overlap. B is the place of overlap, and B is the only place where you can file the lawsuit because the cause of action has also arisen in B, and plaintiff's subordinate office is also there. The jurisdiction of A, which is the plaintiff's principal office, because of this overlap in and this decision of the Delhi High Court, will then be ousted. So this is in general the development of the law on section 62 and 134. Like I said, other high courts and have taken different views on whether this serial number 3 example fits. So again, you have to be conscious. This law may vary. IPRS versus Sanjay Dalia, of course, is the Supreme Court of India. And then this is the Delhi High Court Division Bench, which adds this exclusion at serial number 3. Just to give you a few examples, now here if we say, for example, in this slide, infringement is in Delhi, plaintiff is in Maharashtra, and defendant is in Maharashtra. Now, where all can you sue? Where all courts will have jurisdiction based on cause of action. Cause of action has, if it has arisen because of infringement in Delhi, then under section 20C, courts in Delhi may have jurisdiction. Based on where the plaintiff is based, or where the defendant is based. There is no overlap of plaintiff and defendant with the cause of action. So if there is no overlap, then IPRS versus Sanjay Dalia and Ultra Homes don't come into play. So the analysis is then first, what under section 20 can you do and what can you do under 134 and 62? And the third level is, do IPRS and Ultra Homes come into play or not? So here the third level of inquiry is not required because there is no overlap. The second example here is plaintiff is in Delhi, defendant is in Uttar Pradesh, and the infringement has happened in Maharashtra. Now again here, you have to again check, where is there an overlap of the cause of action with either the plaintiff or the defendant. Since there is no overlap here, again your analysis can start with section 20 and then move to 134 and 62 depending on what IP right is involved, and an assessment can be made on that basis. Now here we come to a third example where there is a plaintiff which has its principal office in Delhi. The plaintiff has a branch office in Maharashtra where the defendant is also based and has its office, and the infringement has also happened in Maharashtra. Now in this situation there is an overlap. So we have to come to the third layer of assessment of whether IPRS and Ultra Homes will apply. Ultra Homes if you're before the Delhi court. Now in this situation, because of application of the two decisions, principal office is based in Delhi, but that jurisdiction is ousted. So the jurisdiction then moves to a court in Maharashtra. Now, if you do initiate or are a part of a lawsuit for IP enforcement or defending one, then what are the reliefs that are likely to be involved or in play in this sort of a situation? There's injunction, and injunction is there are many different stages or types of injunction that are at play and are involved in such disputes. There's ex parte, which is in the absence of the other party. There's ad interim, which is till the next date of hearing. There's status quo, which is you maintain the status as on date of passing of the order. There's interim, and then there's permanent. permanent is after trial, interim is during the pendency of the lawsuit and the trial. And there's a new concept of a dynamic injunction, which has been identified before the Delhi High Court and other courts. And a dynamic injunction does this. Once there is an injunction granted by a court, and and this is usually in the case of rogue websites, where there is a strong likelihood that the domain name registrant, once you injunct a website, they will make a few changes to the URL and mirror the content, infringing content, on another website. By, for example, if the first registration was under .org, they'll go to a .com or a .in or a .co.in. So in these sort of situations, the court has devised a mechanism to not burden the plaintiff with the requirement of filing a fresh lawsuit each time this mirroring of counterfeiting happens on the internet. In this sort of a case, once the plaintiff has an order of infringement in its favor, a decree, the plaintiff needs to go to file an application before a joint registrar along with an affidavit saying that this is a new URL, this is a new website which mirrors the content of the old website, and I stated on affidavit that this is exactly it. So in website blocking orders, these dynamic injunctions are also being granted. There's maintaining accounts, that's a form of interim reliefs, and rendition of accounts is the final relief that can also be considered in a dispute of this nature. And damages. Damages, of course, have a range of principles that apply to them. There could be damages based on accounts, there could be damages based compensation, or it could also be punitive in certain cases. Now, it's important to cover these unique reliefs because in IP dispute resolution in India, we have seen these reliefs play a very effective role in resolving disputes effectively. So the first is Anton Pillar roving. So Anton Pillar and Anton Pillar roving. An Anton Pillar order is a search and seizure order, and a roving Anton Pillar order is a search and seizure with respect for a certain geographical area, like a specific market or an area of a market, for a certain duration. So, for example, if it's Diwali season and you expect a certain counterfeit product to be available in a certain limited jurisdiction, then a court may consider that for a span of maybe a few days, a local commissioner may visit the area regularly to seize and search infringing material. So that's an Anton Pillar order. This is where local commissioners are appointed by courts to embark on this search and seizure request to preserve evidence. Then there's John Doe orders. Again, John Doe orders, well, this is when you don't know all the parties that are infringing. So you make John Doe, as in you don't know the person. So you and make them a party without knowing their constitution or the details of such a party. Now, these orders are specifically recognized by judge-made law. Adding a party without knowing details does not is not contemplated under the Code of Civil Procedure as such. So this is judge-made law under 151 of the CPC, where John Doe orders can also be passed in certain IP disputes, and this is mostly in cases of rank infringers like counterfeiters or websites or infringing websites that only have infringing content. Another relief that is explored in these cases is a Marigold injunction, which is blocking the accounts. Again, this is effective because once that supply of money to a counterfeiter is stopped, usually the infringing activity is slowed down or stopped. Website blocking, and this is becoming more and more important in today's day and age. Again, the law on website blocking has evolved and quite a bit over the last few years. Can you get an injunction against a specific URL versus can it be an injunction against the entire website? There are principles that are laid down by courts, including the Delhi High Court. In what situation can an entire website be blocked versus in what situation can only a URL be blocked? There are also interim arrangements that courts look at by balancing all the considerations and the principles for passing interim orders in a suit. And then there are social reliefs that are granted sometimes. For example, uh, um, the party that is burdened with some token damages is asked to do social welfare in return. For example, donations to charity, or sometimes even plaintiffs take it upon themselves. If they are getting damages, they pledge those damages towards some social cause. So there are a wide range of reliefs that have been tried and have worked in IP dispute resolution. And what is the final resolution in an IP litigation? Of course, there could be a full trial and there could be a decision after trial. We now have summary judgment under the Commercial Courts Act. In ex parte matters where the counterparty does not appear before court or stops appearing before court and is proceeded ex parte decrees may also be granted. Settlement is also another option and is used commonly by parties to finish litigation or to resolve a dispute. It could be outside court, it could even be mediation where court refers the matter to mediation, um, or it could be a simpliciter withdrawal where parties decide that the dispute can be resolved by, say, a contract or an out of court settlement and consequently withdrawal of the dispute or the litigation that was there. So this was by and large my presentation. Um, and I'm happy to take any questions if there are any.
So I request
Yes,
all participants, if they have the question, they can take it up.
I
Zoya.
have, I've got a couple of questions, Abhilasha, and really thankful that you presented in such a simple manner, in such a practical, all the practical aspects of this act. So I'm just give me a minute. I'm taking these questions. Just a minute.
Sure.
So the first question is, if 120 days and 45 days are not complied with by any of the parties under the Commercial Courts Act, does the court proceed ex parte, and will it be detrimental? Won't it be detrimental to the plaintiff?
So a consequence of, say, for example, if you don't comply with the 120 days deadline for filing a written statement is you forfeit your right to file a written statement. That does not mean that you will not be able to participate in the trial or cross-examine. So you still have that option available as a party whose right to file a written statement is closed. But yes, your hand is tied behind your back then, because you will not be able to contest with the same force where your written statement, right to file a written statement is closed. Now, a consequence of a closing of right to file a written statement could also mean an 810, where a court feels that there are sufficient facts to now dispose of or decree a suit. So it may not even reach the stage of trial. So it may not be always to the detriment of the plaintiff, where the right to file a written statement is closed. But yes, for a contesting party whose right to file a written statement is closed, it is a significant disadvantage. And why this disadvantage is now built into the statute is to ensure that there is space to the litigation. Otherwise, one strategy that is employed in litigation is also to see if delay works in your interest or not, and then to facilitate that delay. So this is why this mechanism has now been introduced by legislation. As far as replication is concerned, now replication is a pleading that we commonly file in Delhi, and it's actually an additional written statement in the CPC. It's not recognized as a pleading called replication in the CPC. So the absence of a replication may not harm you as much if the plaintiff does not file a replication, because there's already the plaint which is on record and there is a written statement that comes on record. Uh, but if you miss your affidavit of admission denial, which is supposed to be filed within those 45 days, that may prejudice you more seriously. For the reason then, the absence of an affidavit of admission denial would mean that you're automatically admitting the documents of the other side, which may not be very conducive to the strength of your case. So the impact of missing 120 days for written statement may be different from the impact of missing 45 days to filing your replication.
All right. Thank you. The next question is, what type of disputes arising out of contracts between parties can be subjected to arbitration?
So, as far as now, because we're talking in the IP aspect, most aspects of contracts can be arbitrated. But when you add the layer of IP to it, some areas of IP will then be carved out of an arbitral dispute, which cannot be resolved by arbitration. For example, validity of IP rights. Now, these are statutory granted IP rights. Can these be arbitrated or not? Is actually, in a way, there could be arguments to say certain aspects not declaring an right to be invalid, but something short of that could still be arbitrated. For example, you could still arbitrate on facts if you're talking about licensing of IP, and in that dispute is referred to arbitration. And in that licensing discussion, there is the idea of what is the licensing fee that should be paid. Now, to determine a licensing fee, the commercial considerations can be decided by arbitration. But if, as a part of that discussion, there is validity of the IP which comes into question, then this is a gray area. To what extent can the validity of the IP be argued before a tribunal? Of course, the tribunal cannot declare any IP to be invalid because these are statutory granted rights. But can the tribunal still take into consideration arguments that may impact or that are based on validity of a right to arrive at any other commercial term? This is still a gray area. But if it's otherwise just a licensing dispute, doesn't question into doesn't the validity of a right doesn't come into question at all, those kind of disputes should generally be arbitrable, even in IP matters.
Great. The next question is, please explain the confidentiality of subject matter of dispute among the parties and how the arbitration is a better forum over litigation. Court
Abhilasha, can I ask you to first close this PPT, please?
Oh, sorry, I'm sorry. I didn't realize it was still sharing.
Yeah. Zoe,
Let me repeat the question.
yeah, please repeat the question for the speaker.
So, please explain confidentiality of subject matter of dispute among the parties and how the arbitration is a better forum over court litigation.
So, okay. Now, the way I understand the question is, does confidentiality give a bonus point to arbitration over litigation?
Yes,
That's
I
my
think that's what.
understanding of this question. Now, whether you go for arbitration or litigation, your first consideration is of usually, and if you're entering post transaction, that is, the transaction document is already in place and there is an arbitration clause. You have to first see whether litigation is even feasible or not in that sort of a situation. So, if you're coming after fact, then your options are limited in terms of whether if there is a binding arbitral clause in the first place. Um, if you are advising, or if you're in the picture at the stage when parties are still in the process of finalizing transaction documents, what should be subject matter of arbitration in that, what should be subject matter of litigation, then you look at what kind of dispute it is. Usually for arbitration, you look at factors such as what is the value, right? Where do you want to arbitrate? What will be the total expense in arbitration? What kind of arbitrator do you want? How complex is the subject matter, so that you can think of a appropriate institution or appropriate arbitrator. So those factors go in consideration when you decide, is litigation better or is arbitration. You get interim reliefs. There are options in both, but what is faster? In which jurisdiction is the counterparty? Do you think litigation will be more beneficial to you in that jurisdiction versus arbitration? So you have to think of these factors. There's no general declaration really one is better than the other. It has to be examined on the facts. As far as confidentiality is concerned, there are mechanisms now in place even in litigation, especially commercial disputes, where you can set up confidentiality clubs to keep proceedings confidential. You can file documents under the protection of confidentiality even in litigation now. So as far as confidentiality is concerned, you will be able to play it out in both areas. Having said that, in arbitration, the players are limited who will handle that confidential information, versus litigation. There may be many more participants who will handle that confidential information. So, depending on how critical that information is, and if it matches with your overall evaluation of tilting in favor of one of the two, you can align your objective of confidentiality according to that as well.
Thank you. The next question is, what is the time limit for filing application under Section 46 of TM Act?
Section 46 of TM Act. This is for rectification, if I'm not wrong. Let me just check the provision, because I don't want to give an incorrect response really. Just bear with me for a second. Yes. So this is an application. I think the question. So it's basically 46.4. I think the question will really apply to for
Maybe Miss
non-use.
Sujata can ask in person if she's there.
Yeah,
Maybe clarify it more.
that will be helpful. Oh,
Yeah.
if the person is here, I could.
Miss Sujata, it's your question. Could you take it up personally? Miss
She's
Sujata?
she's
Yeah,
here. Yeah.
yeah.
She's not
Sorry,
there.
the hello,
Yes, I can
hello.
hear you. Please
You
go
can
ahead,
hear me.
Sujata.
Yeah, the application is maybe it is a 47 for rectification of application. Yes. Yeah,
Yes,
I want
in
flash.
this situation,
Yeah.
it depends on what non-use you're alleging. So if you're saying it was never filed with the intention of use, then of course there is no timeline. Sorry, then there is a simpler timeline that you need to comply with.
Mhm.
Just 1 second. Yeah, if it's without bona fide intention, then you can do it 3 months before the date of the application if there is no use. Now, if for non-use under 47,
Mhm.
this calculation is a little bit complicated because it says for a continuous period of 3 months before the date of filing and plus 5 years before that. So the discussion really is 5 years plus 3 months. Is it
Mhm.
a continuous period really, or is it 3 months uh, uh, right before the
Before
filing of the
filing the
application,
application.
or any 5 years before that?
Okay.
So, Sujata, I'm not sure which of the two interpretations fit, but if
Mhm.
you can share your contact details, I could discuss this offline with you to hash out which of the two will actually fit under 47.
Okay, madam. Please give me your contact number.
Yes, so I think I could share it with Nitish, and if Nitish has your details, then I could share it with
Sujata ma'am, you just share your number on the chat box. We'll contact with you with the speaker.
Okay, Mr.
Thank you. The next question is by Mr. Sachin Banduni. He asks, what are effects of non-registration of an IP, and what if the defendant pleads or challenges the validity of the registration?
Again, so it will help to be more specific about what is the IP involved. So non-registration of IP will have different impacts on different IPs. For example, if a patent is not registered, there is no right under the Patents Act. On the other hand, if a trademark is not registered, there
He's
could
saying
still.
trademark. Sorry to interrupt. He's saying trademark.
Okay. So for trademarks, there are common law rights which are recognized under the statute in India. There is a carve out which saves common law rights, which are rights generated by use of a brand. So it could be use generates goodwill and reputation. So that is protected under Indian law. So you don't always need a registration to enforce rights in a brand. So non-effective registration, you have to see how long a brand has been used, whether there are rights apart from a registration in a brand. And there was a second part to this question. If a defendant pleads or challenges the validity of a mark, of a registered trademark, if you plead or challenge the validity, then you have to consider what is the impact of Section 124 of the Trademarks Act on the litigation.
So with this, we'll take the last question, Abhilasha. This is, can you throw some light whether the remedies and reliefs by the tribunal are in rem or in personam in relation to the IP laws?
Okay, by a tribunal. So, if you mean a tribunal, not a court, so the IP tribunals are well, they decide on validity of the IP right. So, validity of an IP right, if being decided by a tribunal, like such as the IPAB, those will operate in REM because that's the title of an IP which is decided. On the other hand, tribunals they may pass reliefs even in personam sometimes. Those will be limited to the parties. But if it's about validity of an IP right, that will obviously apply in REM, not personam. But having said that, there are all kinds of consent orders that are passed, even by tribunals sometimes. So if it's a consent order, you have to see what the order language of the order is to decide whether it operates just interstate the parties or even against everyone else.
Thanks. Thank you so much for taking the questions patiently, Abhilasha. Now, over to you, Ms. Nubresh.
Yeah, Abhilasha, today you discussed this something called dynamic injunction. I just heard it, first time from you. So can you just tell in what all cases this dynamic injunction is being granted or being applied by the parties?
Sure. So, dynamic injunction is an injunction which has been introduced in a decision by Justice Manmohan. And I think in 2018 or 19 is when this decision was passed. What dynamic injunction is being used is against rank infringers or website that are rogue websites. So, for example, if there's Pirate Bay and you identify piratebay.org as the party, which is predominantly a rogue website, and you get an injunction against it. It doesn't take much for the infringer to, change the .org or put a hyphen between pirate and bay and come up with the same content on another domain name. So in these sort of situations, a dynamic injunction is now being granted. And the details of the decision which recognizes these, just 1 second, I think I have the name offhand here. This is UTV software of Justice Manmohan. It's a 2019 decision.
I'm so sorry. There's another question Ms. Sujata is asking, so I'll just take it up. Whether the party can approach. Can you hear me?
Yes, I can.
Whether the party can approach tribunal for removal of the trademark and also file a suit for injunction.
Yes, that both options can be availed. You have to see if 124 of the Trademarks Act, how that impacts this decision, and based on that, you can decide the timing of filing.
So yes, now we are done.
Okay,
With the
great.
questions.
I've just seen the clock. We are almost done. Yeah, over to you, Komal, for the thanking note. That was such an informative session by Abhilasha.
Thank you for such an incredible webinar, Ms. Abhilasha ma'am. It was truly an informative and articulative session. Teaching about this topic was an eye-opener to us. It was during these hard times we can only learn via digital platform. Learning new perspectives allow us to gain an insight about the laws and the norm of IP dispute resolution. Thank you once again for an excellent webinar session, ma'am. And at last, I would like to thank all our viewers who took out time to attend the webinar session. Over to you, Nitesh, sir.
I would like to conclude by the words Abhilasha, very firm and a thorough session by you with regard to the IP dispute. And I would also like to thank, Kritika is here, uh, who had given me a reference, and because of her, it has been made possible to get you here on our board. So thank you, Abhilasha, for this wonderful session. We would like to hear you from another, having been in the another informative sessions. Thank you, Zoya. Thank you, Komal, and thank you, Siddhi. And with this, we conclude today's webinar. Thank you very much, all of you.
Thank you.
Bye.